All right, let's talk about tiers of scrutiny. What are tiers of scrutiny? They are relevant in constitutional challenges to laws generally applied mostly by federal courts. Generally, you'll read about this as applied by the U.S. Supreme Court, but other courts do apply these tiers of scrutiny, which are set out by the Supreme Court. They refer generally to the amount of deference that will be shown to a law, either of Congress or a state law passed by a state legislature. And generally, we will be conducting an ends means analysis of the law, which means we're going to look at what are the ends that the government is seeking to fulfill throughout this law, and what are the means, what are the ways that they go about it. And we're going to compare them and sort of balance them against each other with varying tests depending on what the law is. Let's go ahead and start with rational basis. This is the basic test. It's the most widely applied, and it is the oldest of the three tests. It is extremely deferential. The law is presumed to be constitutional. When you're applying a rational basis level of scrutiny, it's very hard to overcome, although it can be failed, although usually not on its merits, usually on the basis of pretext or animus, which we will talk about later in this video. The ends means analysis, there needs to be a legitimate government interest, which sort of could mean anything. It's deliberately vague. And rationally related means, also very vague. The means just need to sort of be related to a rational basis. We'll talk a little bit more about this later in the lecture. I have a couple of examples, but just wanted to throw it out here. This is the first one. Generally, if you can imagine a reason that the legislature passed the law, it will be constitutional. They don't need to say it. It doesn't need to be in the record. If the court can imagine some reason that you rationally made this law, it will pass. This does a lot of work. One example my old con law professor used to give was if the legislature passed a law that said different star signs have different speed limits on the interstate, that would probably pass rational basis scrutiny. The legitimate government interest is general safety, police powers of the state, health, safety, welfare, and morals. You're clearly within health and safety. The rational means there are certainly people out there that would believe that people drive differently based on what their star sign is, and the legislature could have concluded that that is important, and we need to have different speed limits based on your star sign. And that, I think, gives an example of why this is so easy to pass, right? It doesn't need to be the reason. If we can come up with some reason that you pass this law, it will pass, and it will be allowed to stand. The general areas where this is applied is in sort of general economic / property regulation. These are within the state's traditional police powers. We're not really concerned about anything sort of illegitimate going on here. Generally, we'll let the legislature do what they want in the state. And that's important because the courts are not here to police stupid laws, right? The legislature should generally be allowed to regulate how it wants to, and so the courts are not going to get involved. However, there are times when we need a little bit less deference, when the courts need to take a closer look. And the first time the courts really get into the business of this is in Caroline Products in 1938. The couple of decades before Caroline Products, there had been some movement, as you might have seen in a previous video. There's been some movement on rights. We're starting to incorporate rights against the states. States are starting to sort of interact with the idea of being bound by things in the Bill of Rights and substantive due process. And so maybe we don't always want to have such a hands-off approach like we do in rational basis. So Caroline Products is the first time we sort of nudge at maybe we need a higher level of scrutiny. The case itself deals with the Filled Milk Act, which made it a crime to essentially label milk that was a different percentage of fat than it actually was. That part is irrelevant. The court applied rational basis scrutiny and upheld the law, but Justice Stone, in a very famous footnote here from Lexis, is Headnote 8. Of course, it should be Headnote 4 because it's footnote 4, is one of the most famous footnotes in all of legal history. And you can see the text reproduced here. You can feel free to pause and read if you want. There's a lot of cases cited. But what the justice is saying here is we didn't apply anything higher here, but there are times when we might want to. And those times are when there's sort of three broad categories where we're not saying anything, we haven't laid out a test, we're just speculating, we might want to show less deference. And those are areas when legislation appears on its face to be within a specific prohibition of the Constitution. Generally, that means fundamental rights. So if a state is trying to abridge or interfere with a fundamental right protected by the Constitution, we might want some higher scrutiny. We also might want higher scrutiny when there's a law that deals with a discrete and insular minority that sort of generally has morphed into modern equal protection jurisprudence and protected classes. So if there's a protected class that is, being oppressed or potentially benefited, depending on the era, then we'll apply a higher level of scrutiny. And finally, laws impacting democracy or the democratic process. This one has not really been picked up by courts in the future. It is, of course, in the footnote, but if you've read cases like Rucho versus Common Cause, you'll know that this issue has sort of been punted on by the Supreme Court. So this one hasn't really gotten picked up, but it could be a bit of language, a footnote that could be picked up for future courts if they want to start applying higher levels of scrutiny to things dealing with voting, democracy, etc. That has morphed into the modern idea of strict scrutiny, which is the highest level of scrutiny of the three of them. Strict scrutiny, if we go back to our ends means analysis, requires a compelling state interest, and narrowly tailored means sort of needs to be an extremely important government interest, right? It needs to be compelling, and you have to narrowly tailor your means essentially as narrowly as possible. If you could have achieved the law with more tailoring, then it will fail strict scrutiny. Basically, you want to impact the least number of people. So if we're going to let you, if you're trying to interfere with the First Amendment, that's okay. It might be allowed if there's a compelling state interest and narrowly tailored means. The saying is sort of strict in theory, fatal in fact. Strict scrutiny is very hard to pass. Almost all challenges that come up under strict scrutiny do fail, and the law will be struck down. It's very hard to pass. The first example of it ever being passed, sort of interestingly, is Korematsu, which upheld the Japanese internment program during World War II. That was one of the first times it was ever applied, and the first time that I know of that it was passed by the law and it was upheld. Generally, this applies to constitutional rights and to recognized minority groups. That's the equal protection side of it, pretty much as Justice Stone would have wanted on the footnote. So the footnote has been applied pretty well in this area. This is this heightened level of scrutiny when you're dealing with constitutional rights or discrete and insular minorities. There is sort of an intermediate level, creatively called intermediate scrutiny, which, if we do the ends means, requires an important government interest, so not compelling, but important, and the means have to be substantially related. So there's a little bit more breadth here that we'll allow. This applies pretty much only to sex-based discrimination, and I think comes out of sort of a feeling by the courts that we don't need to apply strict scrutiny to sex-based discrimination because we're not as worried about women or men sort of being cut out of the democratic process, not being able to react to something being passed because they do make up roughly half of the voting age population. But also, maybe we don't want to be like completely hands-off like rational basis is because there could be something going on here. And so they come up with this sort of middle ground where it needs to be important and substantially related, but like not as tight as strict scrutiny. So sort of, if you have a good reason, we'll let you do it. Craig versus Boren is the first time this comes up. This is one of my favorite cases. This fun little picture calls it also justice for beer drinkers. It was an Oklahoma law that dealt with the selling of near beer, which is like low alcohol beer, not non-alcoholic beer, not normal beer, but sort of middle of the road, low alcohol beer. Excuse me. And it required you to be 21 if you were male to buy this near beer, but you could buy it at 18 if you were female. So if you sort of stop and ask yourself for a second, would this pass rational basis scrutiny? Is there a possible, any reason out there somebody could consider that we want to limit the selling of alcohol, of an alcoholic product, to men for longer than women? Presumably it would pass. This would pass rational basis scrutiny. But it doesn't quite pass intermediate scrutiny. The government does not have an important means of doing this. The health benefits were not fully fleshed out, and so the court does strike this down, but at the same time invents intermediate scrutiny. So, as always with con law, the facts are not always as important as sort of the rule or the outcome or how the court is reasoning through something. This is intermediate scrutiny. It doesn't come up very often, but if you see a sex-based discrimination, generally this would be subject to intermediate scrutiny. Let's talk through an example. This is the case that came out of Wisconsin in 2010 after the very controversial collective bargaining law, or making Wisconsin a right-to-work state via Act 10, by Governor Scott Walker. I'm from Wisconsin, so this seemed like a great example to walk through this. This court case, obviously, courts take a while. A couple of years later, talking about whether this law is constitutional. So the law, in relevant part here, banned collective bargaining generally, but it only applied to non-public safety workers. So public safety workers like police, fire, paramedics, etc., were still allowed to bargain. So the law basically didn't apply to them. It banned collective bargaining for everybody else. And what I want you to ask yourself is, does this trigger heightened scrutiny? And again, that means the basis is rational basis. That's our default. If there's some reason it needs to be heightened, then it goes up, right? So if it's a sex-based discrimination, it would kick it up to intermediate scrutiny. If it involves a constitutional right or implicates a discrete and insular minority, that would kick it up to strict scrutiny. So take a second, think about it. Does this trigger heightened scrutiny? If you said no, you would be spot on. There's no protected class here. Your sort of classification of your job, public safety worker versus not public safety worker, there's no protected class there. This is just sort of a normal economic regulation, and there's no fundamental right. So if a court had found a fundamental right to collectively bargain at some point, then this would be implicating that right, and it would trigger strict scrutiny. But because that isn't the case here, there's no protected class, there's no fundamental right, we would conclude that there is no reason to trigger heightened scrutiny, which will kick us sort of to our normal. We're not kicking us anywhere, actually. Just stay at our default rational basis review, which, again, is extremely deferential. The court says the state need not actually articulate their reasons or produce evidence to sustain the rationality. The basis also need not be in the record. If the court can imagine one, that's enough. Obviously, that's very deferential, again, to the state. Right? They can pass virtually any law they want. The burden is on the challengers to essentially prove a negative. You need to prove there is no rational basis for the law. The rational basis review is somewhat hard to get your head around sometimes because it is so deferential. And that's because it applies to these sort of general economic regulations. The court is not in a position to question whether or not we should be letting workers collectively bargain. It might be good policy, it might be bad policy, but that's for the legislature and the democratic process to deal with, not the courts. We don't want to subject the legislature to the court's sort of view of these policy matters because they're not the entity that's the best suited to deal with it. So here, under rational basis review, the law is upheld. The courts are not going to touch this with a 10-foot pole. I want to also talk briefly about animus. This is the main way that you fail rational basis. You're not really going to ever see proving a negative. That is not a way that you're going to fail rational basis, that a law can fail. But you will with animus and pretext. So a word quickly on pretext. If a court decides that you are pretending this is an economic regulation, but actually you're trying to do something else, we will not let you do that. An example of this sort of is Lochner. If you think about this, Lochner versus New York, the court says, hey, you're claiming this is a safety regulation. We know what you're doing. You're actually trying to regulate the economy, back when that was not allowed for various reasons. That's a pretext, right? You're putting forward one argument, and you actually have an ulterior motive that we don't like. That doesn't come up super often. Neither does animus, but it's sort of been a little bit more common recently, and it is relevant to cover for rational basis. A law that's designed to denigrate, annoy, oppress a particular group sort of just fails essentially as a matter of law. It's not really clear why it fails. It just isn't the kind of law that is constitutional. The Constitution just does not let us pass laws that show animus to groups. Great example of this is Romer versus Evans. Colorado passed a constitutional amendment which banned localities from giving protected status to people on the basis of their sexual orientation. So you could not, Denver could not pass a law saying, equal protection for everybody, no discrimination. You can't discriminate. Laws banning discrimination were themselves banned. This law failed because of animus. Justice Kennedy, writing for a 6-justice majority, said it is not within our constitutional tradition to enact laws of this sort. And that's sort of that statement that I was kind of trying to articulate earlier. You just can't do this. This is just not constitutional. A bare desire to harm a politically unpopular group cannot constitute a legitimate government interest. It just cannot be constitutional. We will not let you do this. It is not okay in our constitutional structure. And so even under rational basis review, he sort of signals that by calling out legitimate government interest. Remember, that is the ends section of rational basis review. It just fails. This law fails as a matter of law. You are not allowed to do this, even though we're not going to apply heightened scrutiny. You just can't do this. That wraps up our discussion of tiers of scrutiny. Let me know if you have any questions. Always happy to answer those, and happy studying.